Hi everyone, I'm Nicole Israel. Thank you so much for joining me today in this 8th episode of my In Trust with Nicole series. I really appreciate you taking the time to learn about wills, trusts, and estates, and how you could better plan for your life and keep your loved ones out of court and conflict. Now, this week's question comes from Patricia, and Patricia asks, can I leave my 401k to my minor children when I die? Which is a great question. Now, in general, you shouldn't. That's a short answer. Though you are technically allowed to name a minor child as beneficiary of your 401k, IRA, or any other employment-sponsored retirement account, it's really never a good idea. And this is because minor children cannot inherit the account until they reach the age of majority, which can be as old as 21 in some states. So if a minor child is listed as the beneficiary, upon your death, your retirement account would be distributed to a court-appointed custodian who will be in charge of managing the funds, often for a fee, until the age of majority. Now, what you can do, what we do suggest is you set up a trust to receive those assets instead. And you can name a trustee to manage the account until your child comes of age. And by doing so, you get to choose not only who would manage your child's money, but within the trust terms, you can stipulate how and when the account's funds should be distributed and used, which can help them from being lost or even squandered. So, Patricia, I hope that answers your question. And for everyone else, definitely feel free to email me anytime with your questions about wills, trusts, and estates. I can be reached at info@NicoleIsraelLaw.com, or just visit the website, NicoleIsraelLaw.com, for some basic information and some basic questions you may have about the estate planning process. And just thank you again for joining me today, and please stay tuned again for next week.